Welcome. Let's explore the fascinating world of writs and their role in the Indian legal system. High courts in India hold significant power under Article 226 of the Constitution to issue certain writs. These are essential legal instruments, used primarily to protect fundamental rights and oversee lower courts or other official bodies. There are four main kinds of writs that are commonly discussed. Habeas corpus is used to challenge unlawful detention. Mandamus is utilized to compel a public authority to perform its duty, especially for safeguarding ongoing schemes. Prohibition helps prevent an inferior court or tribunal from exceeding its jurisdiction, effectively quashing proceedings or orders. And certiorari also aims to quash proceedings or orders, but by transferring a case from a lower court to a higher one for review. Our discussion today will also touch upon specific rules, such as the Madras High Court Writ Rules from 2021, which provide detailed guidelines for writ petitions. These Madras High Court Writ Rules, enacted in 2021, are specific to the Madras High Court. Their main purpose is to modernize and update the formats for petitions, streamline filing procedures, clarify service norms, and set clear timelines for writ petitions. Key provisions within these rules cover important aspects like issuing notices through digital portals, requirements for language translations, and specified timelines for filing counter-affidavits. When it comes to instituting proceedings for writ petitions, there are a few key steps. First, the procedure for filing a writ petition involves specific requirements for drafting. This includes detailing the parties involved, establishing jurisdiction, outlining the cause title, and clearly stating the specific relief being sought, known as the prayers. The petition also needs to include content requirements like listing dates, grounds for the petition, and any supporting annexures. Second, the actual filing process covers details on the fee structure and provides information on e-filing. It also specifies the service rules for delivering documents to other parties and outlines the timelines for respondents to file their counter-affidavits. Finally, the rules provide important guidelines for urgent hearings and interim reliefs. This covers situations like ex parte hearings, the drafting of interim orders such as stay orders or interim mandamus, and information on any attachments or security bonds related to these interim reliefs. Let's briefly touch upon hearings in high courts. Generally, there are two main types of hearings, the admission hearing stage and the final hearing stage. At the admission stage, the court's primary purpose is to screen the matter, assessing if the case has any merit or an arguable point. This helps prevent court dockets from getting overwhelmed with cases that lack substance. During this stage, there are a few possible consequences. A case might be dismissed in limine if no arguable point is found, or the court might issue notices before admission asking respondents to file a reply, often with the intention of resolving the matter quickly. Alternatively, the court might directly admit the case for a final hearing by issuing a rule nisi. The final hearing stage is where the case is heard in much greater depth after it has been formally admitted. The arguments presented at these two stages differ significantly due to their distinct purposes. Now, let's explore a powerful concept known as public interest litigation, or PILs. In essence, PIL is about using the law to advance human rights, equality, or address issues of broad public concern. While the concept was borrowed from American jurisprudence in India, PIL specifically signifies litigation brought for the protection of public interest. What makes it unique is that it's often introduced not by an aggrieved party, but by the court itself or by another private party. It represents the power given to the public by courts through judicial activism. PILs can only be filed in the Supreme Court or a high court, and their concept aligns with Article 39A of the Indian Constitution, aiming to deliver prompt social justice. They can address a wide range of issues, from pollution and terrorism to road safety and construction hazards. The significance of PIL is immense. It's a vital instrument for social change, maintains the rule of law, and makes justice accessible, especially to the poor and marginalized. It also helps in judicial monitoring of state institutions and serves as an important tool for judicial review. Despite their positive impact, PILs do come with certain issues and challenges. One major concern is their misuse, with many cases involving personal or irrelevant matters, which contributes to the backlog in courts. In fact, the Supreme Court has expressed displeasure about this and issued guidelines for accepting PILs. Another challenge is the conundrum of competing rights, where a PIL action might benefit one group but inadvertently disregard the livelihoods of others. such as closing a polluting industry affecting its workers. Procrastination is also an issue, as PIL matters, even those concerning disadvantaged groups, can remain pending for years, making judgments merely academic. Lastly, there's the concern of judicial overreach, where the judiciary, through PILs, might sometimes venture into policy-making or executive functions. Regarding the way forward, former Attorney General Soli Sorabji offered some key recommendations. He suggested that dubious PILs should be rejected at the threshold, sometimes even with exemplary costs imposed. Petitions challenging important projects or regulations after significant delays should be dismissed outright. It's crucial to uphold the principle that, just because a petition is termed as PIL, does not mean that ordinary principles applicable to litigation will not apply. Finally, he recommended that PIL petitioners should be held to strict terms, possibly by providing indemnity or an undertaking to make good any damage if the PIL is ultimately dismissed. In conclusion, for all advocates, every case undertaken is a powerful opportunity to make a positive impact on someone's life, champion justice, and uphold the rule of law. Your dedication, timeless efforts, and commitment can truly shape the course of lives and communities. Embrace every argument as a chance to refine your skills, learn, and grow, and never underestimate the value of persistence in pushing through adversity. Remember, the focus isn't just on winning cases, but on ensuring fair and just treatment for every individual you represent. Being a voice for the voiceless and a beacon of hope, it is crucial to uphold the highest standards of integrity and justice, letting your advocacy be a force for positive change. Understand that your work can shape the legal landscape and leave a lasting legacy for generations. Be fearless, and let your passion for justice be the driving force behind every argument you make. The legal world awaits your brilliance. Keep fighting for what's right, keep championing justice, and never forget the incredible impact you can have. Thank you. Welcome. Let's explore